Our first guest is Beth Heckert, our district attorney, is going to talk about legislative updates from the last session. So, Beth, thank you.
So although we're in the midst of the 2020 session, this is the legislation from 19. So 2020 is still a mystery. I'm hoping since it's a short session, they don't do a lot on criminal law stuff anyway. So if anyone has any questions as I go through these, please feel free to wave a hand or something and I'll try to answer those. So legislature last year did do some pretty major changes to the murder statutes in Oregon. So we used to have ag murder and murder, and now we have ag murder, murder one, murder two. So aggravated murder can only be now under the new legislation in four pretty restrictive circumstances. So one is it's premeditated intentional murder of two or more people under terroristic circumstances. So that probably is not going to get used locally. I mean, if you had that type of a circumstance, that's like an airplane, other type of terroristic threat to the government, probably going to be prosecuted federally. So those cases probably are not going to be handled on a county basis. But so that will be a pretty limited circumstance. Murder while confined as an inmate if the defendant was already convicted of aggravated murder. So these are cases that Marion County would see. So if they had a convicted aggravated murder person in prison, and they commit a murder, they are eligible for the death penalty. That was a last minute add into this. And then premeditated intentional murder of a child under 14 and premeditated intentional murder of a police officer, a correctional officer, a parole and probation officer. And this was all effective on September 29th of 19. The issues with this part of the legislation is that premeditated was basically taken out of the code in the 70s, so we don't know what it means. We don't have a legal definition in our code to tell us what it means. So it'll probably be many cases taken up to the Court of Appeals to make sure that whatever definition we decide on a county by county basis is going to be something that's going to stand up to appeal. It's very limited on when it can apply. So aggravated murder is when you could get the death penalty in Oregon, and it'll be very limited under those four specific circumstances. The sentence for aggravated murder could be death. It also could be life without parole or life with the possibility of parole, which was the same that we had before. It did apply to all pending cases, so that was kind of a bit of a surprise. You might remember some of the media issues around that. But we had two cases, I believe, in Jackson County that went from aggravated murder charges to murder in the first degree. Those weren't cases where we were trying to go for the death penalty in our county, so it didn't really have a big impact on us. But around the state, there were cases that were trying to go for the death penalty and now wouldn't fit this new law. And so those also became murder in the first degree. So murder in the first degree is like a whole list of things here. These were the things that used to be aggravated murder. So a murder for hire, you had a previous conviction for murder, you murdered more than one person in the same criminal episode. That was probably where we saw that we used the statute the most of aggravated murder, was murder of more than one victim in the same episode. Torture, the intentional killing of a child, a police officer, a juror, all of those things. So those now are murder in the first degree. And the sentence is 15 years. If you're 15 years or older, life is the sentence with a minimum of 30. And if you're 18 years or older, it could be life without parole. But as I wrote here, it just says if the judge states reasons on the record. That probably is not going to hold up very well to appeal challenges, but we'll see again. So some of the problems with that are, this is exactly what the statute says. So the court may sentence a person to life imprisonment without the possibility of parole if the person was at least 18 years of age at the time of committing the murder, and the court shall state on the record the reasons for imposing the sentence. We don't have any direction as to what that means. What are those reasons going to be? So it's going to be up to the courts. Prosecutors will suggest reasons, and the courts will either adopt those as sufficient reasons to impose a life without parole sentence, and then that'll be again tested with the courts.
On 15 and above with 30 years, Are they eligible for second look?
Yes, and they get a parole hearing in 15 years. I have a slide that talks about that also. So yeah, yep. So they made some changes to that as well. So then murder in the second degree is basically what used to just be murder. So and the sentence for that, if you're 15 and older, is life with 25, with a 25-year minimum. So this was a pretty big change to our legislation as far as murder goes. But we're kind of working through it, trying to figure out how it's going to apply, to the future cases. And like I said, we had a few cases that that changed what they were, and even just the mechanics of how do you change it from if you had charged murder before and now it's a murder in the second degree. It's really just a caption thing, but how do you actually change it? So we've been doing it by interlineation, I believe, is how we've done most of them with no objection from the defense. Stipulation, yeah. So, that shouldn't be any reason that the defense wouldn't stipulate to it. But again, it's like when you make kind of major changes to the criminal justice system, but with no manual as to how we're supposed to do those changes, and the legislature really not having a good understanding, I think, of how those mechanics work to do that. But so there's a couple other big changes, but a lot of kind of small, minor ones. They added additional people to be mandatory reporters. So already, teachers, attorneys, doctors, police officers, a whole bunch of people are mandatory reporters. And what that means is you are required to report child abuse, whether you learn about it through your work or whether you learn about it through your personal life. It doesn't matter. If you learn about child abuse, you have a duty to report. So they've added a couple more people. Now, animal control officers are added to the list of mandatory reporters, and anyone who's serving on a school district board member or a public charter school governing body member are now mandatory reporters. So every session it seems like they add a couple more people to this list, and this took effect January 1 of 20. If you violate your mandatory reporting, it's just a violation, so it's like a traffic ticket, but it does make you a mandatory reporter if you serve in one of those roles 24 hours a day. They did some work on House Bill 2013 on unlawful possession of a firearm. So it's now illegal for a felon to possess ammunition as well as the firearm. And if you have a restraining order or you're convicted of certain crimes, domestic violence crimes mostly, then you're now going to have to dispossess yourself of firearms and ammunition. So they really created a very complex system, and we're working through, again, how this is going to work. So the court would inform the person if they get a restraining order or they get a conviction, for example, for assault in the fourth degree and domestic violence, then they are going to be told by the court that they have 24 hours to dispossess themselves of their firearms and their ammunition. The way you can dispossess yourself of those things is you can turn them into law enforcement for just safekeeping, holding until it no longer applies to you. So for example, a restraining order is typically good for a year, but it could get dismissed at 3 months or 4 months or 9 months. And so if you turn your firearms into the police department is holding them until you come back and say, I'd like my firearms back. Then they'll run a background check on you and see if they can release them to you, and if they can, they will. So someone who only has maybe 1 or 2 guns, maybe that's not as big of an issue for like the Sheriff's Department or Medford Police Department. But we have people, who might own 20 guns or more, or large guns, or a real variety of things. So I don't know if that's really posed an issue yet, Sheriff. Have you seen very many people do this?
No, we really encourage them to find a family member that can take them. We don't want to be the de facto gun storage. There's some liability, some of them are valuable, and if they're not in the same exact condition that they thought they were when they brought them in, do we get sued or whatever, or have to absorb those costs? So we don't encourage them to do that, but we won't turn them away if that's their only option.
And so you can also give them to a third party, a family member or some other person who doesn't reside with you. And then that person has to sign like a declaration saying they understand they can't give them back to you until the time period is up. They have to go through a background check to make sure they're allowed to take them from you, because maybe they have some disqualifying conviction or mental commitment or something that would make them not able to take them from you. You can take them to a gun dealer. I'm assuming the gun dealers are probably charging people to store them. I haven't really heard from anybody on kind of how that part is working. But so if you don't do these things, then the district attorney's office can file a contempt charge against the person for failing to abide by this court order that they were told to dispossess themselves. So let's say, for example, you don't own any firearms. There's a form that you fill out and you just check a box that says, I don't own any firearms. You turn that into the court, you provide that to the district attorney, and that satisfies this statutory requirement that you've complied with that statute. So we've seen a few people using that. You can also tell the court how you disposed of your firearms. So you can say, I provided them to the sheriff's office or to Medford Police Department, and here's the receipt. And so there's some documentation that goes along with that. You provide that to the district attorney's office. We get that in the court, and there's no contempt filed then. There's also a box you can check that just says, I invoke my rights and I'm not going to answer these questions. So if someone checks that box, we are also feeling like they've satisfied what the legislature set out here, and we are, taking that as our notification of. That doesn't really tell us anything of what they've done. But if that person, after they've checked that box, was later found to be in possession of firearms or ammunition, then it could be the crime of unlawful possession of a firearm. So it's just too new. This just all took effect on January 1, and so it's kind of too new to know how it's going to work out. We've already filed not that many contempts, but I'd say a handful of contempts for people who didn't follow the statute. Sometimes what we're finding is when we send them a letter saying we've charged you with contempt, then they are complying. They're turning in their forms, they're doing whatever. Those cases are getting dismissed when they comply before their first court appearance. And we'll kind of just play it by ear as how
Last
much.
week we had them bring it into court. Would ask the deputy DA, can we dismiss this? And yes, they would agree after they saw it. So yeah, it's not before court sometimes, it's during court.
During
when
court,
they're-
yeah.
I thought you were talking they were bringing their firearms into court for a second.
Dispossession
Hold on.
occupancy.
There's the box, right? Yeah, so.
Yeah, well, we hold them at the entrance.
So it really has, it'll be interesting to see, I guess, a year from now, I'll be able to tell you like how many contempt charges we actually filed on this, how many unlawful possession of weapon charges we filed. It really created a pretty convoluted system for us to follow and try to abide by, so we'll see how that all works out. Someone at the legislature has a sense of humor because Senate Bill 420 was the marijuana set-asides. So that's a statute that just makes it easier for people to get rid of an old marijuana conviction. We aren't seeing a ton of people following through with this statute yet, but it just took effect the 1st of January. And there's really not many grounds at all for the prosecutor to object to them to set aside their conviction if they follow through, and they reduce the cost. So used to be you had to submit your fingerprints to Oregon State Police with a fee. Now you don't have to do that if this is the conviction you're trying to set aside. So,
I know it says qualifying marijuana convictions. Are things like a commercial quantity or?
Those are the ones that aren't, and I'm honestly not totally up to date on our marijuana stuff. I have a deputy that just goes through this stuff constantly because it seems like it's changing all the time. But if like it was a B felony, let's say you got your conviction 10 years ago and it was a B felony, today it would be a C or an A misdemeanor. You can change it to those, and then you could go through the process of setting it aside during the normal course. So it's kind of can be a two-step thing, or you can just set it aside if it's been long enough, and you would have been eligible to do that already, but now you can do it with less fees. So I think we've only seen like 1 or 2 of these so far. Some people might carry their marijuana conviction as kind of a badge of honor, so they may not want to be getting.
Does it mostly just like, I know you said you don't know, but just like if they're optional, like delivery within 1,000 feet of school marijuana, would that be?
That one would be one that would not be set aside, I don't believe, any longer, because it still is an A felony. So some of those are what we have to look at, and I'm not positive. Do you know, Judge, if that's still an A felony? I think it is. They just are changing so frequently that I haven't kept up with them. This statute change really was a pretty minor change. It just says that if a police officer is interrogating a juvenile, they have to record it. And if they don't record it, then there's a jury instruction given to the jury saying recordings are more reliable than people's memories. This was a change of the law about, I think, 2 years ago or 3 years ago for all felonies. So if you were interrogating a juvenile regarding a felony, this was the law. And this just made it all crimes. So now if you're even talking to a juvenile about a misdemeanor crime, you need to follow this. There's some exceptions, like if they just make a spontaneous statement to you, or make a statement that's incriminating when you just ask them like their name or whatever, some questions like that. This I don't think has been an issue at all for law enforcement because they were already complying with it for the felony. And we have so many officers now that are wearing, like patrol officers that are wearing body cams. Most detectives don't have any kind of a body cam, so they have to use a handheld device when they're recording these. Senate Bill 1002 put a limitation on prosecutors about negotiating certain types of leave. So you have a whole bunch of different kinds of leave. Everyone gets good time, or everyone gets credit for time served. So if you've been in custody and you've served 60 days on your sentence that the judge ends up giving you, you get credit for that 60 days. So everyone gets that. But there are a whole bunch of other transitional leave, short-term transitional leave, alternative incarceration programs, and earn time that can change a person's sentence pretty significantly. So we weren't really doing this very often in Jackson County, but in some counties, they were negotiating those things away from the defendant. So they would say, we'll recommend an 18-month sentence, but we're recommending, no alternative incarceration programs and no short-term transitional leave. And so then that would be agreement that they made, the judge imposed that, and then that's what would happen. All of the leaves can take quite a bit of time off of someone's sentence. So like, for example, on a 40-month sentence, if you get earned time, a 40-month sentence becomes 32 months. So if you're getting earned time. If you get earned time and short-term transitional leave, a 40-month sentence becomes 28 months in prison. And if you get all of those things plus AIP, which is alternative incarceration program. So you participated in some program and they reduce your sentence because you participated in the program. A 40-month sentence becomes 22.6 months. So it's really kind of eroded sometimes what the judge is saying in court and what the victim might hear is going to be the sentence. Oh, that person's not going to be out for 40 months. And in reality, they're doing all these programs, they're getting out in 22.6 months. So we're trying to educate victims about that 40 months doesn't really mean 40 months. And this statute just made it so we aren't allowed as prosecutors to negotiate this. The judge can still not give one of these programs if they chose to, but we can't negotiate it. Yeah.
Excuse me, I just don't know this stuff as well as everybody else in the room, but
No.
You said in prison. Did you just mean in prison, or does this also apply to in jail?
No, these are all prison reduction programs. So these are all applying to just people who are in prison.
These laws do, but there are time credits for people that are
Right,
serving
people
local
will
jail
get credit for
sentences.
time served. If they serve a county jail time, everyone gets credit for time served.
Good time.
Earned
And
time,
good time
same
reductions.
difference, yeah.
Yeah. But this was really intended at prison negotiations. It was the legislature's intent on this particular statute. It was interesting because last year I was the Oregon District Attorneys Association president, so I worked up in Salem quite a bit and talked with a lot of legislators, a lot more involved than I had ever been before. And sometimes it was a little disappointing in how district attorneys were being viewed kind of statewide. And so some of the legislation we see is just a direct result of that. So this one, another major change, Senate Bill 1008 is the Juvenile Measure 11. So this did make a lot of changes to ballot measure 11. So that was passed in 1995, and it meant that every 15, 16, or 17-year-old who was charged with these particular serious crimes would receive a mandatory sentence, is what it originally kind of came out as. So what this does now, and they were automatically remanded to adult court. You didn't have to go through any judicial proceedings or a hearing in front of the judge. It just happened automatically. So this changed a lot of that. So now we have to go through a remand hearing, a waiver hearing. And I didn't go into it a lot here, but the They basically also changed the reasons that we can remand a juvenile and the things that we need to look at, and they're much more skewed kind of in favor of the juvenile. So really looking at the juvenile, not looking as much at the crime they committed or victim's impact or anything else, but really looking at how, how advanced is this juvenile, how educated are they, how much could they maybe improve if they were just left in the juvenile system. So that's really kind of the focus of all of this legislation. So if we do want to remand a juvenile, we have to go through a hearing. Because I've been a prosecutor for 33 years now, I've actually done remand hearings. There was a ton of people in the Oregon District Attorneys Association who had never done one in their counties. Like the people who are in the offices now had just never done these. But those of us who date back before 95, we used to have to go through the same process. If they're waived, then they are eligible for parole in 15 years. It doesn't mean, it just means they're eligible. It doesn't mean they'll get paroled. It just means they're eligible for that. So there'll be a hearing on any of these juveniles before the court at that 15-year mark to see if they should be released. And it doesn't matter if they have consecutive sentences, if they had multiple victims, any of those things that we used to be able to kind of stack sentences and not have them be eligible for these programs. Now they will be eligible. So just, kind of the worst case scenarios, someone who's a school shooter or something like that, had multiple victims, could get out in 15 years from when they entered the juvenile system, if they were 15, 16, or 17 at the time that they committed the offense. Someone who committed a murder was 300 months before or 25 years. Now they could, again, get out at 15 years. So we'll have hearings just to determine how they've been doing in the institution, what they've accomplished. There is an opportunity for victims to give some input at that hearing as well, and then it'll be up to the judges to decide what should happen with that person. Danny also mentioned second look hearings. So they've also expanded second look hearings to every youth is entitled to one after serving half of their sentence or turning 24.6 years. So when you enter the juvenile system, if you were 15 or 16, you don't just stay in the juvenile system until you're 18. You can stay in the juvenile system until you're 25. So like McLaren, our youth correctional facilities, Rogue Valley Youth Correctional Facility in Grants Pass, you can stay in that facility until you're 25. When you're 18, you can be moved out to Department of Corrections. And most kids that I've seen that we've sent to the youth correctional facility stay in the facility. If they're benefiting from the programs, if they're working through their issues, if they're going through the things and they're causing problems, then they stay in the youth correctional facility till their 25th birthday. If they're causing problems and they're over 18, they can be transferred over to Department of Corrections. And that all happens just between the institutions. That doesn't involve any hearings or anything like that. It just happens between the institutions. So now every youth who gets a sentence will be entitled halfway through their sentence to have a second look hearing. And that hearing, we've been doing those for a while, but ballot measure 11 cases were exempted. So now those ballot measure 11 kids who got sentenced to a youth correctional facility for, say, a robbery in the first degree or robbery in the second degree, they're entitled to that second look hearing. They aren't going to serve, they didn't get a 15-year sentence, so they're not going to fill into that 15-year, automatically get a hearing at 15 years. That's pretty much going to be homicides. But you could have a robbery who got a 90-month sentence, or a juvenile who got a 90-month sentence, and halfway through that sentence, they're going to have a hearing. Those hearings, the burden is on the youth to show that they're rehabilitated and they should be allowed to go back into the community on parole. And we've done a handful of those over the years because before it wasn't the Measure 11 kids and it was only kids who had 24 or longer month sentence that got those. So we hadn't had as many. I don't imagine we're going to see a whole lot more of them here. A lot of times they're kind of good because you really see kids who have excelled and have really done well in the programs and should be entitled to getting released. But we've also seen people who just didn't participate at all or got in more trouble while they've been in the institutions, and then the judge didn't allow them second look release. So they went through the hearing process So I don't know that we're going to see a whole bunch more cases on that. This one also was effective 9/29 of 19, so it had an emergency clause. So all the cases that we had pending who were Measure 11 youth charged with a Measure 11 crime that had automatically wavered over to adult court because it was the way the statute worked before, we had to transfer those. We had 2. We had to transfer them back to juvenile, and then we made the decision not to try to remand them. They were both cases that we were in the midst of negotiating a lesser sentence than Measure 11 with them anyway, so it just didn't really make sense to transfer them back over to adult court, because they still, as long as they were going to not turn 25 during that time frame, they still were going to serve their time in the youth correctional facility, and so it just didn't make any sense to go through that process. I'm sure we will have some cases come up where we do go through a remand hearing if the facts are appropriate for that as we look at it. Jackson County was a county that actually usually didn't use Measure 11 to charge juveniles who are charged with sexual offenses. We didn't use Measure 11 to move them to adult court. We typically left them in juvenile because there was good programming in the institutions and good sex offender treatment and so forth. So in some ways, this kind of allows that process that we were already doing to just to fit within the law. We were having to call something different, an attempt or something like that in order to negotiate it that way and keep those youth in the juvenile system. So in some ways, this wasn't a bad fix. It would have been nice if it didn't apply retroactively, but for our county, it didn't make a huge difference. You heard more about this, the mental health House Bill 24 last week from Judge Greif. So this just really kind of tried to limit how many people we can send up to the state hospital, and some extra community resources we should use before we send someone to the state hospital. It is very expensive to send someone to the state hospital, and so they were trying to kind of curb counties from doing that. So if you're, for example, charged with a misdemeanor, which was pretty rare for our Jackson County to send someone to the state hospital on a misdemeanor, but we did have 1 or 2 over time. Now you have to have a certified evaluator or a community mental health director recommend that they go to the state hospital. And so it just kind of added some more hoops. And then I think Judge Greif hit on it too. If someone can't go up to the hospital, then they can be held in jail, which is not the best place for people who are suffering from mental illness. And the court has to hold a hearing every 7 days. And what we're seeing sometimes with those cases is they're just statutorily timing out rather than really getting some help. But we're working. We have one deputy who's just assigned to work on the mental health cases, and so he works to try to either see if civil commitment might be appropriate for that person. Are there other resources in the community that we can engage them in and dismiss the criminal case? How can we get that case resolved? See, when they can't aid and assist, then they can't really move their criminal case forward, because the attorney is saying, my client can understand the process. So even if it's a simple case and everyone can kind of agree this might be the best thing for that person, the attorney can't move that case forward because they don't understand the process. I mean, so sometimes it kind of puts us in a difficult situation, but it also makes us come up with some creative solutions for how to deal with some of these folks. And this also had an emergency clause, so it went into effect July of 19, and we've started an extra docket to kind of deal with this with the courts, and Judge Greif talked a little bit about that. So House Bill 3224 just required the district attorney in every county to post our policies on our website. So anyone in the community could look at our policies. And we don't have to comply with this until December of 20. But we're well ahead of this curve, and I think we'll be posting our policies probably within the next 30 days. So we've been working on just getting our policies all together. So we would have policies and procedures of a whole bunch of topics. And the legislature listed a bunch of topics, but we have policies and procedures that go beyond just those topics. But if, for example, the district attorney's office wanted to affidavit a judge, we didn't feel we could get a fair hearing in front of that judge. That's not something we've done at all in Jackson County. It's very, very rare around the state. But we have to have a policy of when we would think about doing that and what procedures we would go through before we would do that. So we'll have all of our policies up there well ahead of time. Any of you want to come and look at our policies, you'll be welcome to look at them. There's one question, yes, John.
I've been on this group board for 11 years, I think, and I have to say that I am so impressed with the goodwill and the innovation and the collaboration to try to help people through all the difficulties that get them involved with the criminal justice system. The community doesn't get it in this county or in my city, what you people are actually doing. And I don't know what to do about it, but I do know that Pam Marsh is in the legislature now. And I've worked with Pam for years and we're friends. And Pam is now in the leadership. I don't know if you all realize that yet, but she's one of the 7 women in the House who are running the House. And if Pam could be an advocate for Jackson County and for you all in these interactions. And so if there's a way that you can think of where maybe we get Pam and some of you together just to give her an understanding of the work you're doing and the issues you're encountering with the legislature. She is a hard person to push around on an issue I'm talking about now within the leadership. Just from past experience of working on our city council, she can be a very good advocate.
Yeah, and I do meet with her about whenever I see a legislative proposal, and I've reached out to all of our legislators to say, if you get something, just call me up and I'll talk to you about it. You don't have to accept my opinion, but at least I can tell you how this could impact us or maybe things you hadn't thought of about it. And I do have a good rapport, I think, with all of them, and there's been kind of a good open door to just discuss those things.
Who's in charge of compliance? Who do you have to answer to? I mean, aren't you an independent entity, county rule? How does the state?
There's no penalty written into the statute. I hope nobody goes that route. Because I believe they will write a penalty.
Yeah, there's no.
Right. There isn't a penalty for if you don't comply with this statute written into the statute. So hopefully DAs around the state will just embrace this and post their policies on their web pages. But if a county doesn't, it wouldn't surprise me if the legislature goes in and says that I could be held in contempt if I don't do this or something.
There are a lot of laws that require us to do things and have no penalty. But I mean, someone could potentially have a civil case if you're not following the law. And the other thing is, even though we're a home rule charter county, I would say it's a matter of statewide concern because it's addressing statewide prosecution. So I don't think the county has any legal authority to regulate it in any way differently. I mean, to make it less,
Right. It could be. It could be an issue in your next election, I suppose, too. I mean, I don't know.
To your point, though, generic's the only way to really write that. Paul, I don't know why you would hem yourself in and write something that's.
They usually have some out a little bit of why you might override this policy. This is our general policy, but here are situations where you can go to the chief deputy or the elected DA and possibly get an override to this policy. So
it just should stay in your policy that you maintain discretion.
Right.
That is your policy.
Right.
I mean, I'll argue that.
Yeah.
I mean, along with whatever else you're, regulating.
I just like that short.
Yeah.
Prosecutor's discretion.
Yeah.
I can tell you we have probably put in 100+ hours on trying to get our policies, just gather them together in one place, which is a good thing, and that's what we were working on before this even became an issue, just so that they could be, because we're getting to be a larger office of 21 deputies, and so just so you could kind of hand them something that said, this is the policies of our office, so you could, be trained on it, and defense could look at it. So.
Hasn't there been Court of Appeals cases on state or DA not following their negotiation policies? I thought I've seen those.
There was a couple, for when you, I can't think of the word now, but when you joined thefts together, there was a particular case that said if you didn't have a policy on aggregation. If you didn't have a policy on aggregation, then you couldn't do aggregation just ad hoc. So we had a policy on those kinds of issues. So there have been a few.
I thought there was one about basically this defendant being treated different than others. But I don't have the case. It was a long time ago. But
yeah, I'm not positive of that one. So this one was Kaylee's Law, and this doesn't apply in our county, but just so you would know, this was a Deschutes County case where a young woman who was a college student was picked up by a college security officer who murdered her. And some people looking at the facts and the scenario afterwards thought, it may not have been clear to her that this was a security officer, not a police officer. So they've put a whole bunch of things in there. None of these are happening in Jackson County with any of our campus security type of police. But they can't have caged cars. They can't have cars that look like police cars. They can't have uniforms that look like police cars. So it really just did a good job of trying to identify them as what their role actually is and not as police officers.
I'm just pointing this out for people's knowledge. This is really interesting to me, the psych testing to determine fitness, because when I ran parole and probation, you could be armed as a parole and probation officer, but you were required to take a psych test. But police officers are not required unless by policy. There's no law that requires a police officer to take a psych test.
There is now, though.
Is there now? Mm-hmm. Yeah. It's just amazing how they kind of independently apply this rule of psych testing.
Yeah.
They just changed it this last, I think the last legislative update.
This was a fix. House Bill 2328 was a fix to the unauthorized use of a motor vehicle, so stealing a car. We had a court case come down that made it more difficult to try to prove these cases. And so now it just changed the standard to a person is aware of and consciously disregards a substantial and unjustifiable risk that the owner of the vehicle doesn't consent to them taking. So we had some cases around the state where, you say, some guy on the corner gave me the keys to this brand new truck, and so I thought it's perfectly fine that I drive it for the next month. Well, how do you get in touch with that guy? I don't know. I don't have a way to get in touch with him. But they kind of could fit under the statute. Now that won't be a problem. Up in the Portland area, this was really a big issue, and so that was part of the push for this legislation. We did not see a big change in our unauthorized use of motor vehicle cases down here. We occasionally would get one that we just didn't think we could prove, but we weren't seeing a big drastic reduction. And in Portland, the reduction was dramatic, that they couldn't go forward with their cases. So,
isn't it a problem that they still say knowingly, but basically they define knowingly as recklessly?
Yeah, it could be. It helps a little bit. There always are more things you can adjust and change with these, and there, as I saw in the process, a lot of it is compromise, who wrote the bill and what they thought of it. So, on this statute, it amended an intimate image. So if you now don't have to just send an intimate image on the internet, you could text an image from one person to another. That was a kind of a loophole in the law before, and so this fixed that. Senate Bill 577 changed intimidation, is what we used to call our bias crimes. Now it's called bias crime. It added 2 layers to it, so we have second degree and first degree. So this is if you're motivated by what your perception is of the person's race, religion, gender, sexual orientation, all of those things. And so again, changing it to a bias crime, people felt like it described it more, and people would understand what it was than intimidation. And this one has a couple data, gathering up data information. We are not one of the 3 pilot counties. So those pilot counties are going to start collecting data this year, and then the rest of the counties will have to start collecting data on July 1 of 22. So just which cases we're prosecuting, why we filed, why we didn't file, a bunch of information that the legislature is going to gather to figure out, I guess, why we don't have more of these crimes in our state, or what the other issues are with this particular statute. And then this prostitution statute, we didn't, this isn't a big issue for us either, but if a person calls 911 and during that prosecution they disclose that they were engaged in prostitution or attempted prostitution, we can't prosecute them for that. So it wasn't, you sometimes wonder why these statutes got started. What was someone, it must have been a particular case in a particular county where this happened, and then someone felt like, oh, we got to make a law that says.
That was honestly my next question: is who drives some of these house bills? I don't understand.
A constituent can go to their legislator and say, this was a big problem, please fix it, and that might be it. I mean, a prosecutor can go to the legislature, like the UUMV bill fix. We went to legislators and said, this is a problem. The court just came out with these rulings. You need to fix this. So you can get kind of that information from all over the place, but sometimes they do seem kind of odd, whatever the topic was that made it through.
You can pretty much imagine what this topic was.
Yeah. And then one thing that didn't get fixed by the legislature that I just want to kind of put on your radar is unanimous juries. I think I still have another couple minutes. So there was a bill before the legislature to refer this out to the voters. It has to be a voter approved because it's a constitutional amendment. Oregon is now the only state in the United States that has non-unanimous jury verdicts for felonies, not for murder, but for any other felony. We do a 10-2. So we had company with Louisiana. Louisiana changed their law. So there's a case pending before the U.S. Supreme Court that we're all kind of sitting nervously waiting to see how it's going to be decided. And that case is Ramos versus Louisiana. So in the Ramos case, he was convicted of murder by a non-unanimous jury. So that couldn't have happened in Oregon because Oregon still had unanimous for murder. So we're waiting to see how the Supreme Court looks at this. The worst case scenario would be they say unanimous jurors are required. It's unconstitutional to not have a unanimous juror. That will put thousands of convictions in Oregon at risk, and looking at like what do we do about that. So if that was to happen, that's like worst case scenario. All the way to they could very narrowly look at that case in Ramos and say you have to have a unanimous verdict on murder, and that's the facts that they presented with in Ramos. So if they said that would have no effect on Oregon cases because we already had that. That'll have an effect on Louisiana cases because they had been doing that for a long period of time. So I just want to kind of put that on your radar. We have 15 cases only in Jackson County where someone's preserved that appeal issue. The way that we know whether someone's a unanimous verdict or not is we have to poll the jury. And so we have been polling the jury ever since this came up on our radar. But if we didn't poll the jury, we may not know whether they were a unanimous verdict or not a unanimous verdict. And so this just could really be a huge issue in the criminal justice system. Across the state, we only have 15 cases in Jackson County where they've preserved this and they're sitting there waiting for Ramos to be decided. But across the state, there's over 500 cases. And then if they make a really broad ruling, then it's not these ones that are preserved. It might be post-conviction, which means my attorney didn't do a good job because they didn't raise unanimous. And so we could see a lot of cases be returned back to our county to have to try. The 15 cases that are preserved, we've known they were on appeal. So we've saved our evidence. We could try those cases again if we had to, if we can find witnesses and so forth. If it was a really broad ruling, then we've considered the case closed because the appeals time went by, and so we could have cases where we had to dismiss because we no longer have the evidence. The 15 people who are sitting up in prison could get immediately returned to our jail, and we'd have to make room for them because presumably they're all there on pretty serious charges because they've had still serving their sentences and so forth. So I just want to put this on your radar. Every Tuesday, it's like, this is the week. They're going to make their decision. They're going to tell us this Tuesday.
Did you say every other state has unanimous juries for all felonies? Or
Yes.
just for all felonies they do?
Every other state.
Wow.
Yes. Louisiana and us were the only ones who had non-unanimous.
So since this, if they do rule broadly that any felony requires a unanimous jury, then you're talking, like you said, thousands of cases. Mm-hmm. And did DOJ file an amicus? Oh, they did.
Yes. Yep. Yeah. Attorney General filed that. There's an old case, Adapacako or something like that. I can't pronounce the name. I'm sorry. But there's an old case where the Supreme Court looked at our non-unanimous and said it was okay. And so her brief basically says, we've relied on that. You should stick with your old decision and make this a very narrow ruling. So we just don't know. The court's changed a lot in those years, so who knows how they'll decide. But this could really be a huge impact on criminal justice in the state of Oregon if it goes very broadly.
So if there was a voter legislative change to go unanimous, could that remove grandfathering so that would kind of nullify the possibility for all of these appeals? No, it would
not if the Supreme Court is going to say it was unconstitutional, because you can't really legislate something that is unconstitutional.
Well, I'm saying if the legislation were to be passed before the Supreme Court ruling.
No, because that's the position Louisiana is in. Louisiana fixed it in that sense, but they still have old cases that are appealing it. So no, that wouldn't work. The other issue with this, and it won't be dealt with in the short session, but in the long session next year in 21, is let's say the Supreme Court says only applies to unanimous for murder, so that doesn't affect Oregon at all. We still will continue to use a non-unanimous jury system because there is no referendum out to the voters to change the Constitution. So that was the bill that was before the grand jury, or before the legislature in 19, that they killed and at the end, and when it was kind of had broad support, but they killed it because they think, oh, this Louisiana case is going to answer it for us. But if it doesn't, then we're still in the same boat, and someone needs to do a referendum to get it out to the voters to change that if that's what we want to have happen, so that we are then in compliance with the rest of the United States. And then it would be from then forward, it wouldn't affect old cases if we fixed it legislatively like that, or we amended our Constitution. So, any other questions? I'm hoping there is hardly anything to report out of the 20 session. So.
Okay, how's everyone doing? I'm going to try to go really fast so I get everything done, but go ahead and put the hand up to pause me if you need to. I'm going to give you a little update on our jail. This is the same presentation I basically presented before our Board of Commissioners on February 5th on our first public hearing. So it's if you've heard this, I apologize, but I think there's some good information in here for this group as well. Okay, I'm going to go through a quick history. Jail was opened in 1981. At the time, our population was 135,000 or so, and we had about 156 beds to use. One thing to note, when this building was designed, it was designed to have floors go up, as we all know. Seismic standards change, essential service building requirements it's pretty much precluded us from building up without investing in a substantial amount of money to support the rest of the structure. One thing to know, though, in those master plans, the maximum capacity, even going up to 7 floors, was only 283 people. So that means all the other infrastructure, the medical, the kitchen, the laundry, spaces for working with individuals in custody, sewer, all that stuff was designed for 283 people in the master plan. We've already exceeded that. So I think it's just important for people to know that what this building was ever designed to be, we've already exceeded that. We're sued for crowding in 1985. We agreed to limit capacity, release inmates on Monday morning after court, and so different things. We've changed configurations. We've double bunk cells. We got up to 230 at one point, and then now we're at the 300 today. But I will go back and say National Institute of Corrections came in 3 times that I'm aware of. 1999. And what their recommendation was at that time, they did a jail facility assessment, is that we start planning for a new facility in 1999. And when I talk about this stuff, I'm going to talk about different factors that have pushed me to want to go after new facilities. So it's not just size and capacity, but there's other factors too. National Institute of Corrections came in again and did a full system assessment in 2006, and they found that it was a staff-intensive design, and it was not cost-efficient to operate, and that we should plan to construct a new jail. Now, also in 2006, was it 2006, Danny, that you did Pony?
2005, I think, 2005, 6.
Right around the same time?
Mm-hmm.
They recommended, though, we build a jail of about 600 to 650 beds at that time, back then. So then I'm going to go back through 11 years of grand jury reports. So for those of you that don't know, every year a grand jury is convened and they do a assessment of our correctional facilities in Jackson County. They do the jail, they do JDH, or juvenile detention hall, and they do community justice. And so we have those reports are all available online at the district attorney's webpage. In 2008, they recommended that we needed to increase staffing within our jail, in our current building. In 2009, they said the jail is too small and new construction consideration is without question. In 2010, as you know, we had a pretty significant downturn in the market, and the housing and the economy wasn't great starting in 08-09. In 2010, they said jail is understaffed and too small, but economy will not allow a new building.
2011, the jail is understaffed. Add medical infirmary to the jail. Again, we have a very small medical facility for the amount of people that are in our jail. 2012, the jail is understaffed and we need more mental health resources within the jail. 2013, expand staffing, seek additional revenue, more mental health, structural and infrastructural analysis of the existing jail. So in response to some of those, and I wasn't part of this planning process, but only assuming is that the remodel of the basement was conducted to address some of those needs. So in 2014, the basement was opened, 60 beds added to our 230 bed capacity, or 232. So now we're at 292, 2014. Grand jury did their assessment that year and said we still need more mental health resources, and the linear design is outdated and costly to operate. 2015, the basement had to be closed due to lack of staffing. We just simply didn't have the staff to continue operating the basement, and so we had to close it. And it remained closed for the end of 15, or about 8 months, I think, or 7 months in 2015, and all of 16 and a part of 17. 2015, the grand jury said you need to reopen the basement, and that we needed to work on transition or discharge planners. So these are people that would meet with our people in custody once they were getting out and help align them with proper resources within the community as they go out. 2016, the grand jury said a bigger, better designed facility is needed to serve the county. Basement of the jail was opened in 2017 in April. At that, I took office in January, and then we asked National Institute of Corrections to come back and do another system assessment. They no longer provide a recommendation, and that's policy driven. They said they didn't want to say counties need to build a new jail when they might not be able to build a new jail, so they wanted to look at a whole systems approach. They did indicate that a lack of bed space has a negative impact on our criminal justice system, and the jail wasn't meeting the needs of the community. In 2018, we started the FTA program. We dedicated just 10 beds to that program, and I'm giving you a little of this for reference for when we look at some of the statistical data, but that's had a pretty significant impact on our warrants and our failed to appears in the county. But we were holding on to those who chronically failed to appear for court appearances. Although DLR did say when they met with us, we did hire DLR, they came in and they said the mere fact that you have to have said program is evidence that your criminal justice system is struggling here in the county. In October of 18, we bumped the capacity to 315 at night and stopped releasing individuals at all hours. So we do our best to hold on to people from 10 p.m. to 6 a.m. now, and then we have a mindful way of getting them to the community justice building where they have a resource center. And you might ask, why can you hold 315 at night or instead of 300 during the day? And that's really just because of design and staffing. The jail is very difficult to supervise, and there's a whole other presentation we go on that. But it's really the linear design. It's very staff intensive and difficult to operate, and there's a lot of movements that have to be done by hand, which is different, and I say by hand, by actual deputies walking to said doors and pulling people out. Modern facilities are designed a little bit differently. In 2018, the county purchased 49 acres of land for the site of a future jail. And in 2019, DLR conducted the conceptual design and analysis of what said facility. They recommended a 750-bed jail just based on days in custody and the amount of people who were lodged in our facility and best practices. They noted many issues with the current building. And it's important to note that when DLR came in, there's some information going out in the community that there was no public input, that there was no other input than, say, the sheriff or, the county contributing to this. And they sat with the LPSCC, we met with all the criminal justice partners, we met with mental health, addiction services, and all provided input as to what we'd want to see in an ideal facility in our county. So those ideas were incorporated into this plan as we move forward. So early 2019, we went to 11 cities, as you all know, all the incorporated cities, to ask if they would pass a resolution to be enter into a service district that could be voted on by the voters, and 9 of 11 cities said yes at that time. So I think some of the limitations for the cities, or the hesitations at the time, was information. just didn't have enough information to move forward comfortably. So we started community meetings and started doing some educational and some, I guess, think tank type meetings where people could provide input, offer suggestions. We could talk about what we've already done, what we wanted to do. And then in late 2019, we went back again, and 10 of the 11 cities adopted resolutions to move forward. So right now, the process that we're in is the Board of Commissioners have one more public hearing tomorrow, and then they'll make a decision as to if we move to the voters in May. One thing that came out of the community meetings, though, and this was not really, there wasn't a lot of debate about this. So I proposed, as a sheriff, my goals for a correctional facility. And keeping the community safe was the number one goal, right? I think everybody agreed that when you have a jail, the number one priority is to keep everybody in the safe within the community. And if I've been looking at our criminal justice system for 3 years and working in it for many more than that, forced releases don't contribute to that safety. They just don't. People are getting out, they're reoffending, coming back, they get out, they reoffend. So we're not meeting goal one with our current jail. Now we've done a good job. I'll show you some numbers. And I hope people take that as, hey, we're doing the most with what we can, and don't say, well, you don't really need a new jail, because I still believe we do, 100%. But then the second one is keeping the offender safe. So when we talk about keeping the offender safe, what does that mean? Obviously, we don't want them assaulted or injured in jail, but it's also safe from themselves at times. These individuals go out, if we're releasing them, force releasing them, they go out and get other charges, come back, we release them, they get other charges, and pretty soon they're really gone down a path that is almost irreversible, or they may end up in prison when they could have had local things going on. So we're not doing them any favors either. Opportunity for justice. When you talk about correction or criminal justice system, there has to be checks and balances, and if there's something done wrong, there's usually a consequence, and the jail is a place that those things could be honored. And frequently, I know the bench has had some heartburn with, and rightfully so, that we don't honor some of the things that they suggest or hand down as sentences, and it is frustrating. And it also doesn't send the right message to the offenders, because they know that there's no consequences for their actions. And then rehabilitation for the offender. There's certainly no time and opportunity or spaces for that in our current jail, so we don't really offer that, although we are starting a medication-assisted treatment program that's very close, or we identified the 8 or 4 of the 8, right?
Right.
It's going. So we got MAT as of about a week and a half ago? So another reason, proposed facility size. So the best practice is to operate a jail at 15 to 20% under your bed capacity. And that's for a lot of reasons, but classification is one, supervision, safety. And what it means is, if you have a double bunk cell and you have somebody who's antisocial and they're going to assault whoever you put in with them, that 2 beds becomes 1 bed, so you can't fill a jail. You can rarely ever fill a jail. It's not the same. In fact, SCORE, when we toured their facility, they have 800 beds. They said when you hit about 700 beds, people are on the floors. That's just the way it is. So we try not to run at that because it's just too full. And that's pretty common. Best practice, like I said, 15 to 20% under your maximum beds. Currently, we're at 346 beds. So if we ran at best practices, especially in that facility with our staffing, we'd be sitting at about 276. And we're at 300 and 315 at night. So we're really pushing the envelope of what this place has done. But there is such a need in our community when you looked at forced releases and warrants and crime rates that we felt like we had to expand what we would like to be. So our new facility, what we're proposing is going to be about 796 beds, and that'll give us an operating safe capacity of maximum about 650, and that's what we would target. So you got to build 800 beds basically to get 650 people in the jail. Now you could swell up, you could bring in extra staff, and you could do these things, but that wouldn't be a long-term way to operate a jail. Here's some pictures. Now this is Skagit. There's a lot of talk about, the mental health component, the addiction services within a facility. Our facility doesn't quite look this nice on the inside. It was designed in the late 70s. Some people would say there's punishment through architectural design, things of that nature. There's no spaces. But that's what the front of the jail looks like in Skagit County. And that was designed by DLR. And it looks really kind of fancy there, and they do that for a lot of reasons. It's not super expensive. It's a little more than just having a concrete box, but the rest of the jail isn't that. So that's when the public pulls up to the facility and they go to walk in. They feel like this is not a place that their loved one or their family member is in this like concrete box with cages and no lights and all this stuff. It's to present a nice image to the public. And then there's a couple examples of what the housing pods look like. So there's one view from ground level and one from above. This is the command and control area. And each housing pod you can see in from one spot within the jail. So it's very efficient to operate. And you can see they design, there's a rec center, or the rec yard on the far, it'll be on your left. That's what the yard looks like, and it's attached to the same housing pod. So everything can be in and out and supervised through the same spot, essentially. You still have to have roaming, deputies doing their checks and things, but you can see things a lot better than you can in our current facility. There's the hallways and corridors. This is I think that's the medical. Is that the medical, Josh? No, that's not medical. That's the intake. I can't see from here. But there's a hallway. It's separated nice, bright lights, open ceilings, easy to maintain, cheap for maintenance. There's just a lot of advantages to this type of design. And then Judge Mejia will like this. This is a courtroom in the jail itself. That would, in our design, that would provide efficiencies for certain types of cases. You can't do trials in there, as I'm told, but there are some opportunities for arraignments and some other things to help alleviate transporting, people downtown. You don't need to. All right, so criminal cases, civil cases by county. So this was kind of eye-opening for me. We got these numbers from the OSSA, it's the State Sheriff's Association. They compiled these. And when you look at how busy Jackson County is, people say, why do you want to build a bigger jail than some of these other places? Well, one is for growth. That's the number one reason. Economy scale is another reason. But we do have a very busy county. There's a lot of crime here. When you look at the statistics, we filed 9,035 felony cases through our circuit court in 3 years, 16, 17, and 18. The only county that filed more was Multnomah. So we had more felony cases filed through our courts, through our DA's office, than any other county but Multnomah. Is that like, Washington County was the closest. They're only 35 behind, so it's really kind of about the same. But they also have a population of about 600,000 people. Plus they have all the metro areas that surround them, which is, people coming into their county. So we're very busy. And you look at misdemeanors, we're close to, we're certainly disproportionate for our population size. We're at 220,000 people or a little under. And you look at Washington County, we had almost as many as them. We had about the same as Clackamas, same as Marion, and more than Lane. Now Lane, in their defense, they have Eugene Municipal Court. They do all their misdemeanor filings, so they don't go through the circuit court. And they file a lot there. I don't remember what the number was from the presentation, but it was pretty substantial for their muni court cases.
And they have a Springfield jail.
Well, that's another, they do have that, which uses their muni court. So the muni court uses I think 30 jail beds in Springfield because they don't have enough room in the county jail. But also look at civil commitments here. Now, my understanding and what I was explained by Judge Greif was these are cases that were come before the courts. It doesn't mean that everybody was committed up north, but these are reviews, right? And over those 3 years, we're sitting at 2,500 cases coming through our court, and these are primarily going to be mental health related issues. And you look at like Washington County, they had 136. Multnomah County had, much more, but we were by far above and beyond these other counties, especially when you consider our population. Now, I look at this as a positive thing too, because it tells us that officers, and many of these referrals come from police officers who have taken people up to the hospital for evaluation or detox or whatnot. They're not arresting them and throwing them in jail. They're recognizing that this is another issue, and they're putting them through a different process. It could be doctors that initiate these, family members, police officers. Many of them are coming from police. So police aren't de facto throwing people with a mental health issue in jail is kind of the point of this. We're doing this more than many other counties. Bookings and forced releases. So when you look at how upside down we've been, and we've made some improvements, but You look at those 3 years, that same 3-year time period, we had 41,000 bookings through our jail. Deschutes County had about half of that. There were about 30,000 less population. Washington County had a few more. Clackamas is pretty comparable to us. Marion County. But you look at our forced releases, we're almost at 50% over that 3-year period. And these other counties are way down. Deschutes County hasn't reported a forced release. I don't know, have they ever? I don't think they have, Josh, have they?
Not since they got their new jail building built.
So, and they have 450 beds in their jail. But even Washington County, Marion County spiked up this year. They actually surpassed us for forced releases, so we dropped a third in the state, so we're doing pretty good, I think. We've made up 2 places in the last 3 years, so I think that's good. But when you look at like Multnomah County only reported 256 forced releases over the 3-year period, we're certainly struggling.
One thing I just want to have people understand there, one thing that is deceptive about that number of forced releases is it really would be higher if we weren't also releasing people to alternative custody to serve their sentences. So, for example, we have a transition center here. Marion County doesn't have a transition center. So instead of force releasing someone, we release them to an alternative custody, and that doesn't get counted as a forced release, but the truth is they should be in jail in most cases. Now, the length of time varies, but
Yeah.
the last time I looked at it, it was 1 day once you're sentenced is the average length of stay.
We only have one person in custody usually that's sentenced. It's 1 to 2.
Yeah, so I guess what I'm telling you is those forced release numbers are actually really low, even though they're 50% of our total bookings, because people don't stay in jail once they're sentenced. We're moving them out to all these alternative custodies. And it's good that we have all of those things, but we're being compared to counties that don't have them, and we're still doing worse than them.
Yeah, and some counties might have a risk release program they use too in some instances, but this just gives you an idea of the scale that we're dealing with here. We can give you a good example. Just the other day, we had somebody that came in on a probation violation. They were supposed to be in custody for, till the 28th?
I think it was 14 total days.
14 total days. They were actually a witness in a significant case. When they got lodged on the PV, nobody thought the other of it because he was going to be there for X number of days. He was out in 3. He was out over the weekend, essentially Monday or Tuesday, and then it was a grand jury witness in a shooting. We had to go find him, and luckily he was compliant with our deputies when they went and tracked him down, and he didn't hide. But those are just the things that we have to deal with here when that should have never been a part of the equation. He should have been in custody serving his PV, walked over to grand jury, came back. And those are just challenges that we deal with kind of on a daily basis here. Now this is good. So I did 4 years comparison and just looked at bookings per 1,000. So over the last 4 years, we've dropped almost 10 or 9 total per 1,000, and we've had the most improvement out of all the counties. So I think that's good, but we're still really high compared to the other counties for bookings per 1,000. So we're a very busy county.
Can you say a little more about the busyness? Because I hear you say is that we have a lot of crime. And also I'm curious if we have different practices or what is leading to the increased activity with criminal justice, not just on the crime side.
Well, I think we have a few factors. Well, there's a bunch, but real quickly, geographical location, socioeconomic issues, marijuana is a contributor, I-5 is a contributor. We're surrounded by counties that have significantly less infrastructure than we have here. So we're kind of the hub between, say Redding and Eugene, and for all of southwest Oregon, southern Oregon, and it's just a busy place. I don't know really how it has become this way, but when you're looking at like felony cases, the other piece I guess you could say is we have a lot of crime and we have a smaller geographical area or less people, less populated, and the officers know people, so that people don't get away with stuff too. I think that's, they may get arrested. So if they see John walking down the street and they know John committed a theft, they don't have the anonymity they may have in a big city or a big county where they don't have, that relationship with the officers and the community knowing everybody. So I don't know. There's just a lot of factors, I think. Yes.
I think too, our police departments are all pretty well staffed. All of our cities have a police department and pretty good sized departments actually, and that might not be true all over the state. And then some jurisdictions will just have some crimes that they just don't prosecute, and we haven't been forced to go to that kind of a system either. So Like when I talk to other counties about marijuana, they're like, yeah, I don't care about it. They don't file those cases, they don't do anything with them. We've had such crime driven by marijuana cases that we file those cases. And we have a marijuana team through the sheriff's department. So I think there's a little bit of all of those factors really play into why we have the numbers that we do.
And those are good things too, because you don't want to really decriminalize crime because you may reduce strain on your criminal justice system, but you certainly want to improve livability for everybody else, right? If you just ignore things, oh, that's no big deal. That's just not, I don't think, a good practice for our county.
I don't want to slow you down. I really want to see the rest of it. But one of the things that I'm sure you're going to address it at some point, I'm going to guess, but when you went back through all those years of being audited, essentially, it was undersized, but the other thing was understaffed. I mean, almost every one of them was understaffed. How does the staffing grow? If you're understaffed, but you build something bigger, how do you can only design in so much, and you're still going to have the humans. Has that been addressed?
Yeah, so in our plan, we plan for all the staffing, the increased workload. I mean, everything is in this plan, and this is why this plan addresses many of the issues that were brought up, long-term issues with the grand jury. Is it gives us a new facility, it gives us the more mental health, and it gives us the additional staffing to run the facility.
And I'll add to that you wouldn't believe the efficiencies that the modern models also create, right? I mean, in one kind of half of the jail model we're talking about, it houses essentially the same amount of people that are in that entire building, and it takes about a quarter of the staff to supervise those.
Are you mandated by some organization that says you have to have so many officers or per inmates? No,
I don't think there's actually a set standard, but you want to maintain, you want safety in the facility, safety and securities, and if you don't, then you could be subject to civil liability.
It's more task driven. There's nothing that says how many staff you have to.
Okay.
So this slide, if you look at, we closed the bed space in 15, and it was all closed for 16, and then we opened it in 17, and then 18 and 19. You can see these graphs, and these are Part 1 crimes, so those are your more serious crimes. Those are forced releases, warrants, and FTA warrants. So everything has kind of gone down as we've addressed a couple issues. Even Part 1 crimes are down the last 2 years, which is great. And Part 2s are down as well, but I didn't put those in the graph.
When you say since we addressed, everything's gone down since we opened up just those 60 beds and had more space.
We've done a
and
couple
changed,
other things too,
and
like
changed
the
some
FDA
program,
program
right.
and some other things. But the bed space and efficient use of that bed space has helped drive down some of these numbers. And the FTAs it's shocking. I mean, when you look at just the failed to appears in 2017, there were 10,276 times people didn't show up for court. That's not good. And this year we were at 5,100. So in 2 years we've dropped that number by 5,000. That's pretty substantial.
That's just by focusing 10 beds, right?
Yeah.
10 beds on people that.
I mean, if we had 300 more beds, we just wouldn't even have FTAs to this degree. I mean, you still have a few, but I don't know. I mean, I can't speak for the judges, but I can imagine they would only give somebody so many opportunities to not show up to court before they just held them. I mean,
Well, of course, and yes, and your chronic FDA program really helps us identify those people, even if they don't make the top of the list.
On a sort of 40,000 foot view, then what do you do with the jail we have now if this goes through the voters and it's passed?
I don't think there's been a decision made, but I imagine it'll probably be just demolished.
It's likely to be raised, and we actually need the space for more
Yeah, I was wondering what the
courthouse facilities. We may not need it just today.
Sure.
But we're making the new judge work on the third floor right now. We're building a courtroom in this building, but we're not going to get more courtrooms here. So
Yeah, and it's not going to be as big of a court as we actually need because we won't have access to the jail folks. Well, we would, but it'd be a longer trip and traveling through somebody else's territory in terms of court.
We have a courthouse at the jail for some new judge, right? Anyways, high-risk offenders. So this is interesting. This is more Eric's forte, but when you look at offenders, there's a lot of thought that low-risk offenders need fewer touches within the criminal justice system, or you can actually make things worse if you're overbearing. Is that kind of how it goes? But high-risk offenders need more supervision. They need more intervention from the criminal justice system, and they need jail space as an availability for when they don't follow through with their programming. So when you look at how many we have in our county, we have the highest percentage of high-risk offenders in the state. 23.9% is the state average, and I'll show you what ours is. Ours is 39.6. So we're 39.6% high-risk offenders that are under supervision of community justice. And you just look at the numbers. We have 2,400 people on probation or supervision, and almost 1,000 are high risk. That's more than any county but Multnomah, right? So that's a significant issue, and bed space is needed to help deal with those offenders because they are more likely to recidivate based on a statewide universal scoring system. So it's a lot. And that was a snapshot, just for your information. That's a snapshot that was taken on January 17, 2020. That number does fluctuate day to day because people could come off probation, be placed on probation, and then their classification could change. But this is a snapshot from that day.
And just from my understanding, the high risk
means of harming others or of reoffending?
Reoffending, I think, is that correct?
Yeah, likelihood to reoffend. It's not necessarily violent, it's not the type of crime, but the likelihood.
Okay, so then we had audit look at our repeat offenders over 12 months. They did the last quarter of 18, the first 3 quarters of 19. So we had 13,419 bookings during that 12-month period. 6,756 individuals were booked in for those charges. That means unique individuals. So about 50%, roughly 50% are repeat offenders. 1,423 or 21% were booked the other 6,800 times. So 21% accounted for about 50% of those lodgings. And then when you look at, you break it down a little further, 365 people accounted for 22% of all bookings. So we had 365 people that were about 3,020-ish bookings. And so those are our chronic people that are repeatedly, they're going to jail more than 10 times a year on average, or right around 10. It's like 9 point something. And about 45% of the individuals who were cap or forced release failed to appear and generated a warrant. So forced releases do have a correlation to fail to appear. And we've cut the FTAs in half. So mental health. There's a lot of talk in the community about we just need to build mental health facilities, 24-hour crisis center. We don't need a bigger jail. So in Jackson County, admissions to the state hospital for 2019, we average about 4.6 per month. Now, the standards are pretty high to get somebody sent to the state hospital. So there are people that have needs in our community. No one's arguing that we don't need more mental health or addiction services. But the state is responsible with the CCOs to provide a lot of those services. We will say this, we're not sending people up for minor offenses. Beth mentioned this in her presentation, but 94.7% of Jackson County admissions are for felony cases. And when you look at, Marion County is touted as a model that we should implement, like as far as the officers going out and having the crisis response team and the 24-hour crisis center. When you look at their use of mental health facilities in the state versus ours, they actually use more than we do of the state hospital. So I don't think it's illegal. That means that people have committed crimes and are now getting sent up to the state hospital. So we represent 5.29% of Oregon's population, and we had 6.6% of the beds occupied at the hospital. So we're a little bit above average. Marion County represented about 8.21% of Oregon's population, but they had 12.5% of the beds. So I still think we're doing things well here, even though we might not have the bells and whistles programs for using the bed space up there. And then this is just small stuff. We covered this before, but other things to consider why we might want a new facility is it's a 40-year-old building. It's a hard-use building. Plumbing is cast iron. I don't know how long that lasts, but I know we've had pieces or sections of it fail already. That will be a full replacement in the whole building, and it's going to all have to go through the concrete and all the walls, which are concrete. The pipes are in there. So that's going to be a costly and a very long, expensive project. Electrical issues, the panels, the thing wasn't designed for today's amount of current cameras and electronics. When this jail was built, it had a conduit for one computer in it. That's it. And now everybody, as you know, all has computers. Door locks, equipment wearing out. They're heavy use doors, steel doors. It's expensive to maintain. Essentially, according to facility maintenance, the useful life of this building has come and gone, and now we're just going to be maintaining it. But as we consider investments into like new air conditioning units and chillers and all these other things, is it more cost effective to look at the long-term solution? Then the design, like I said, punishment through architectural design. There's some people that would believe, and based on the amount of lighting of what our jail looks like versus a new jail, certainly a possibility. But, you know, a bigger concern is the deputies have to work in these conditions as well as where we house the inmates. So, you know, considering that they spend 25 years, if they spend their whole career with the sheriff's office or more now, because no one can get out in 25 years with the different the PERS system. So 30 years, they got to be in the same building. So let's see. I think elevators. Now our jail has elevators, and that is not a good way to operate because when they go out, which they do, isn't one broken?
I think we just got
it fixed. But one was down for a while. So.
And there's only two.
There's only two. So when one breaks, everyone's down to one, and I mean you just don't want to run elevators in a jail. It's not a good practice. They get stuck. We had a deputy that got stuck in there for 2 hours. I mean, he's getting paid, but come on. He wasn't too happy about it. He had a good attitude, though. So where are we at now? Construction rates are based on standard market inflation, about 5% a year increase. So we were at $166 million when we went back to the cities in early 19. Now we're up to 171 total project costs. And that does include soft and hard costs and the land acquisition that was already done. The building will absolutely need to be replaced someday. I don't know how long that will last. You know, we'll keep doing our best, but it certainly will be a project that has to be completed by the county at some point, and it's only going to get more expensive as time goes on. And
Sheriff Sickle, I have a quick question for you. On your slide where you talk about those, kind of the churning of the system, that this amount of people committed this percentage of the crimes, have you done any type of calculation to show how much the county would save if those crimes weren't committed because the jail had the capacity to hold them, and how it might offset the cost of this project?
Yeah, we did a cost of crime study. One of the SOU students did it, and it was pretty informative. Yeah, he did a good job. We paid on average, like per resident of Jackson County, paid about I think it was like $50 or $60 more. I can't remember. Do you remember the exact number? Somewhere in there. I might even have it in here. No, I don't. But it was like $160 higher than the average Oregonian. Meaning, and he was able to attribute it on a line graph. Our costs go up for criminal justice services, and when you talk of cost of crime, it includes livability issues, missed time at work, insurance claims. I mean, there's all these different factors that go into cost of crime, and we were much higher than the state average, and he was able to kind of pin that to the forced releases. So the forced releases do probably impact those numbers pretty substantially.
Thank you.
Do you have what's the percentage of transient crime? How many people are you arrested a year? Do you have any information that are not domiciled in Bedford?
So the audit report, which is going to probably come out this week, I'm hoping, after the commissioners meeting tomorrow, they talked about homelessness. That's a very difficult thing to pin down, though, with our current records management system we use in the jail, and on the cooperation of the person being booked in. Those are other factors, right? So if somebody comes into our jail and they're very angry with the police because they got brought to jail, and they say, no, I'm not going to give you my address, we have to list it as transient. So then that's counted in as number as not have housing. So audit did do some things where they looked at like the different bookings to see if they changed, you know, with this time they reported transient and this time they reported an address. But it still doesn't really give us a definitive answer. But I think it was like 30%?
I'm reviewing the report right now, and I just read it yesterday. I think it's 10%.
Yeah, I was going to say, I don't think
It's 10% that are transient, and when he looked at the two different bookings, 3 or 4% of the time it changed. They weren't transient from one booking to another, and it's really not honestly dependable because it's self-reported.
Yeah, and again, it could just be there's different definitions. Somebody who down on their luck and really can't afford a house and is generally because of circumstances homeless, and then there's the addicted and people who might choose to live a lifestyle that they don't want to be pinned down. So there's a couple different factors as well. All right, so as we move forward, we have the 3 prior assessments by the National Institute of Corrections, all saying the jail isn't meeting the needs of the community or that we need to build a new one. We have a decade of grand jury recommendations. In fact, we just got our 2021 that we have yet to respond to, but we just got, I think, a week and a half ago. And it said the number one thing is you need to build a new jail, get a bigger jail.
Can we just explain to people, so the grand jury meets like for over several weeks, for a day, a week, I think it is, Fridays or
Yeah,
something.
1 day a week for 9 weeks if they take the whole amount of time.
And this is a whole group of citizens that represent our citizens that have done this over and over and spent hours and hours touring all of the facilities, learning about all the programs.
They talk to inmates, they talk to service providers, deputies, administrative staff, county staff, yes.
I didn't mean to interrupt, I just
Oh.
wanted to get in line.
Oh, yeah. And so, and these are not the same jury every year either. These are all different jurors over the last, forever, I'm assuming.
They toured to the 3.
They toured the jail. Yeah, so it's a pretty in-depth review, but the point of this is these are lay citizens who have no involvement in the criminal justice system who are listening to all the facts, who are saying these are needs that you need to meet. But you have all those, and then, the other thing is you have the professional recommendation from just about every criminal justice professional in the Valley. Now, I can't speak for every single person, but all my interactions understand that this is a significant need in our Valley, and to say we don't need to move forward or have other options is you have everybody who works in the system and has done so for, Beth's been doing it for how long, Beth? 33 years of experience, and our judges who understand that this is a big need. So I think it would be remiss not to move it forward to the voters. Now the voters say no, that's their right, and that's what gets to happen. But we gotta give them an option. Yes.
So thanks, Sheriff. I think the case for the jail is a really solid one, and all of the detail in that really helps support it. What we're going to hear more and more is that we don't have enough resources for mental health or substance use or crisis intervention or whatever the other pieces are. And so I just think making a case, I've heard you say that that's our job, and
I said it's the state's responsibility.
and the state's, right. So
No,
right
it
now,
is
we
the state's
overspend
responsibility.
what we get for those services in the current state. So just having some way to talk to that part would be really good. And I know that we've had conversations with Stacy and others up here to figure out how we partner in that space. But coming with a concept of how we partner and what we want to build will probably be a received message as well.
Yeah, I agree. I mean, for me as the sheriff, my focus is the criminal safety aspect, and I don't certainly mind being a good partner, and I think I have been. I mean, I've been to just about every nonprofit and organization, healthcare. I mean, whatever we can do to try to build bridges and create relationships. But we're certainly going to be, with this plan, I think, able to braid all of those services from the outside and build a big plan. The problem is those plans might take 3 or 4 years to get lined out completely, or to even get on board. And this is going to go up, $15 million each year, and our criminal justice system is still going to be struggling. This won't be open for 4 years. So all those things could be worked on in the interim.
One of the things this is just purely from experience. All the new schools that we built in this valley over the last, let's just say, decade, every single one of them, what happens is you build them, you think you'll never reach capacity. Never. We're building more than we're going to need, and we spend millions of dollars on stuff.
Yeah.
Rivers of tile, because that's going to make kids smarter. And it pisses people off, specifically voters. They walk these schools and go, why in the world do we need an indoor elevated running track and gardens on the roof? You don't need it. I would be very cautious of going to the voters with something that looks really pretty. I get that people want that. There's this feeling that you're going to visit your person. I get it. I'm just telling you the quickest way to turn off voters, because I've seen it on the school side, is to show something that they think is a waste of money.
Yeah.
I would say build more. I would say build bigger. Whatever you think you need, go more and put less shit in it. I'm just telling you, it's the only way to do it and really get the good taste of the voters.
One of the issues I think with mental health is that everything the county does is public. Everyone knows our numbers. Everyone knows what we spend. It's all public. Honestly, the CCOs have done a good job of people not knowing how much they're spending, where you said you're overspending what you're getting, but the public doesn't know what you're getting. They don't know what you're spending. I anticipate between 50,000 people and the split between, all the various services you do, probably around 40 to 50 million a year that the CCOs receive. this sell by NAMI, and it's NAMI who's pushing it, is that we're spending all this money on the jail, but we're not spending money on mental health. And the truth is, we're still spending more money on mental health even if we pass this jail. This is $512 million in new taxes. Do the math. Let's say $45 million a year. You're over almost $900 million in 20 years. At that rate, that's not inflated. That's present value, not future value. $900 million in what we're spending today over 20 years versus $500 million on this jail in new taxes. But the CCOs and the state don't put that information out. So our public doesn't know how much we're really investing in mental health. We just tell them we're doing a lot. They know what the county's investing because all of our budget numbers are online and everybody can read them and they know how we're splitting the money. That's one of the biggest problems, is the perception that we're not spending money in mental health. And I think that the CCOs, honestly, I mean, I'm not just saying this to call you, I think the CCOs in the state need to publish that stuff, and they need to let people see how much we're actually investing.
Well, and ours is public. It's just hard to read and access, but it is public. It's not hidden.
So how much are you spending on mental health?
Oh, I couldn't answer off the cuff.
Well, give me a rough estimate.
No, I can't. But I can come back with that.
Okay.
I can come back.
Well, I think it's good that that information get out to the public, because they think we're not spending money on those services, and we're spending way more on mental health than we are on this jail. Way more. We're putting $5 million in services in mental health in the jail.
Yeah, I mean,
and that's a huge increase, but it's nothing compared to what the non-crisis mental health services are being funded out in our community. It's nothing. And I think it's disingenuous or uninformed of NAMI to push that principle that we have to spend more. We're not spending money in mental health because we're going to spend money in the jail, and it's just not true.
So what I was asking for is a shared message and how we talk about what we are spending.
Yeah, and that's...
But we have to know what we're spending to share that message. I mean, that's my point. Nobody really knows. And honestly, I do think that the CCO you work with is more public, but our other CCO is even a private company, and it's even more difficult to get information from. So I just think it's unfair to... I agree we need to, and we've done that. We've set up the table together. We are working together. The county does want to be involved, and we are involved, and we are a provider through crisis services, more limited scope. But I think people do view all of the investment, because they say it's Jackson County mental health is what we're spending, but it's not true. And the scope of what actually comes here into our state is billions and billions of dollars for these services over the next 20 years. And it's huge. And I wish people could have some perspective when they're making these assertions that we're not doing enough somewhere. The state director set up here last PSCC meeting and told us all the state isn't investing enough. And it is. I agree the CCOs have a contract, I agree with the county, but it's a state responsibility, and they need to figure it out. Yeah.
And I would just say that, yes, all that information would be great, but a lot of people don't look for it, a lot of people don't care, and I just wonder how you're kind of dealing with all these sound bites that are, they're showing up in the paper a couple of times a week.
Yeah, 40% increase in your taxes. So for me, that would be like $400 or $4,000 or $3,000 a year, which isn't true, right? It's a 40% to your base county rate, but if you pay any other taxes, it's much different. It's really, when you look at what the average homeowner in Jackson County will pay, it's like 47 cents a day for this facility.
Well, and even if you look at your Jackson County, we pay $2.01 per thousand in Jackson County. This is 87 cents. That's not 40 cents. Or 40%. So,
but it's a buzz thing, and it scares people, and they think, oh my God, my taxes are going up 40%. So it's a good way to kind of manipulate the actual cost to the individual. And as to your point, Travis, it's a good point with the bells and whistles. So the first time we met with DLR, and they went around the room here, this room, and then they went around with all the law enforcement, all the treatment providers, everybody. They came back with a number, and it was 220. I can't remember what it was. 220 million. It was high, and so we cut out a bunch of stuff that they would say, this is best, this is what you want. And so this facility as proposed, and we haven't gone to blueprints, we haven't gone to the formal design pieces at all, but they would say that what we've presented you is a middle of the road facility. It's not going to be.
I would only add that those schools I'm talking about, more than 50% of them were designed by DLR. So they're prisons and schools, that's what they do. And so you'll just...
You get the base model?
You want base model.
Well, they're not even actually contracted to do the design.
Yeah, that's what I was gonna say. DLR, we haven't bid our.
They did it. They just did the feasibility assessment, needs assessment. So we're not locked into any particular architect to do the design. Any questions? I know we went over, so thank you for staying. If you did, all right, take care.
Sheriff, Beth, thank you guys both. We're adjourned. See you guys both.